our friends who use hearing. Sorry, Ruhama. So your question was whether individuals can directly file their complaint to the treaty bodies. So this is possible, but usually the formal procedure is this United Nations Commissioner for Human Rights would channel the complaints to the respective, treaty bodies. So this is, something ለአሰራር, እንዲመች በሚል የሚካሄድበት process ነው. But individuals can also, or, the organizations which will advocate on behalf of the individuals can also file the complaint directly to the treaty body. So it will be about communicating the treaty body or not. So you'll choose between the two, but usually for your complaint to be seen, for the sake of expediency, it's good if you use the Commissioner for Human Rights in Geneva. Any other question? Okay, Ruhama. I'm glad it's clear now. Anyone who have questions? Maybe if you just lose tasks because of network, I can also, clarify a certain part we have been discussing. Okay, Rihanna. Yeah. Yeah. Exactly. So we said that there are admissibility requirements, and those specific admissibility requirements will be seen by the treaty body. So this secretariat is just, a certain, bureaucratic organ, which will allocate cases to the various treaty bodies. So it's not going to decide on the admissibility of the cases. It's just a bureaucratic organ, and it will, label cases as that these ones are for treaty bodies and these ones are for charter-based bodies, and it will just channel the complaints to the various treaty or charter-based organizations and bodies, but it will not decide on neither on the merits nor on the admissibility of the specific cases. So as we shall see next in our today's class, the specific admissibility issues will be decided by that specific treaty body. This secretariat will only channel cases, for the sake of bureaucratic expediency. The individuals may also file their complaint directly to the treaty body, but they also have this option to just submit it to the secretariat, and the secretariat will just, forward it in less time than a certain individual can do by its own. So this is just a system to make, bureaucracy easier for individual victims. It doesn't have any power to decide on the merits and admissibility of the case. I hope this is clear. Or if you have additional questions, I may clarify on them based on your questions. Is there anyone with questions? You may ask. Okay, so if there are no questions, we can proceed to the respective admissibility criteria. So for a case to be admissible before a treaty body, there are various admissibility requirements. This would vary from treaty to treaty. But generally, there are some admissibility requirements that are accepted over the broad or across the board. So the first one is on the issue of who can bring cases. So when we say an individual, what kind of an individual can file cases between treaty bodies? So that individual needs to be a victim of human rights violation, or it should be someone who presents the case on behalf of the victim. So maybe his advocate, maybe human rights organizations can submit a case on behalf of the victim, or the victim himself or herself are the ones who can bring a case before a treaty body. And second, regarding the format of the complaint, most of the treaty bodies require a complaint in written form. So you need to write your complaint to submit it to the treaty body, obviously. And the third issue that comes forth concerns exhaustion of local remedies. So the individual who files a case before the treaty body or the committee needs to exhaust all local remedies available. And fourth and finally, the case also should not be pending in other systems of international law. So for instance, if you file a complaint before a regional system, let's say the African Court on Human and People's Rights, you cannot also file a complaint under the CEDAW treaty body or the ICCPR treaty body. So the case should not be pending in other systems such as regional human rights systems. So if you submit your case to the international treaty bodies, you should not be dealing with an issue of pendency, whether in the national or regional legal systems. So it's after considering these issues that the treaty body will finally decide on the merits of the case and that it will provide remedies. So let's see in detail what these admissibility requirements are. So as we said earlier, the country must ratify the international legal instrument, and it also needs to accept the competence of the supervisory body or the treaty body. So claims can, only be submitted against states which are parties to the respective treaties and have recognized the competence of the treaty body to consider complaints from individuals. ስለዚህ ትሪቲውን መፈረም ብቻ ሳይሆን ሀገራት ማድረግ ያለባቸው ኦፍኮርስ ትሪቲውን መፈረም አለባቸው፣ ራቲፋይ ማድረግ አለባቸው። ነገር ግን የዛን ትሪቲ ቦዲ የኢንዲቪዥዋል ኮምፕሌንትን ለማየት የሚያስችለውንም ኮምፒተንስ መቀበል አለባቸው። For instance, if you take the ICCPR, there are many states which are signatories of the ICCPR, but individual complaints are filed only if that state have accepted the optional protocol of the ICCPR. ስለዚህ for an individual to file a complaint before a treaty body, the state to which that individual is a national should ratify the ICCPR plus the optional protocol which allows individuals to file complaints. ስለዚህ በICCPR ላይ ኢንዲቪዥዋሎች ኮምፕሌንት እንዲያደርጉ መብትና ስልጣን የተሰጣቸው በኦፕሽናል ፕሮቶኮሉ መሰረት ነው። ስለዚህ ሀገራት ICCPRን ብቻ ሳይሆን ኦፕሽናል ፕሮቶኮሉንም አብረው መፈረም አለባቸው። Some treaties such as the Convention Against Torture do not have an optional protocol, and the individual complaint mechanism is embedded within the treaty itself. So in such treaties, there is no need to ratify the optional protocol because it's not there in the first place. But for those treaties which have optional protocols and it's only within that optional protocols that individual complaint is recognized, states need to ratify the optional protocol as well. So the thing is, states need to ratify the respective instrument that would allow individual complaint mechanisms ማለት ነው. So this is the first important issue that needs to be considered in regard to admissibility. And the second is that there need to be a material admissibility. So ratione materie ነው የሚባለው መሰለኝ በላቲን እና so yeah, the alleged violation ማለት ነው, the alleged violation must relate to a right which is actually protected in that treaty. So therefore, the first step to identify an international instrument that protects the rights or the freedoms which are allegedly violated by that state must exist in the international treaty. ስለዚህ ያለ መብት ነው ተጣሰ ሊሉ የሚችሉ ኢንዲቪዥዋሎች ማለት ነው። ስለዚህ if that right that you are alleging to be violated is not in the treaty in the first place, you cannot file an individual complaint. ስለዚህ ለሲዳው ትሪቲ ቦዲ right to property ተጥሶብኛል ብሎ አንድ ሰው ማመልከት አይችልም። ወይም ደግሞ ለምሳሌ ለICESR ለኢኮኖሚክ እና ሶሻል ካልቸራል ራይት ኮንቬንሽን right to demonstration ተጥሶብኛል ሊል አይችልም። ምክንያቱም right to demonstration political rights የምንላቸው they are within the ICCPR and not the ICSCR on the Economic Social Rights Convention. ስለዚህ the right to be violated need to exist in that specific treaty through which the individual is claiming a remedy. So another issue that needs to be considered with regard to admissibility is reservation. So a state, as you know, may have or can enter reservations when it ratifies a treaty. So through reservations, it may have excluded or it may have altered certain type of provisions of a treaty and their application to its specific territory, or the reservation might in a way limit the treaty body's competence to examine certain communications. So in exceptional cases, the supervisory mechanism may decide that a particular reservation is impermissible because it goes against the object and the purpose of the treaty, and it may consider communications from individuals or complaints from individuals nonetheless. But generally, if a state have entered a reservation, the treaty body will consider that reservation and how it might affect the complaint filed by the individual. ስለዚህ የስቴቷ even though ትሪቲውን ራቲፋይ ብታደርግም ራሱ በሪዘርቬሽን ከሆነ ራቲፋይ ያደረገችው እነዛን ሪዘርቬሽኖች የተመለከቱ ኢንዲቪጁዋል ኮምፕሌንቶችን ትሪቲ ቦዲው አያስተናግድም ማለት ነው። ለምሳሌ ሲዳውን ብንወስድ ብዙ ሀገራት ሲዳው ላይ ሪዘርቬሽን አድርገዋል። ስለዚህ እነዛን ሪዘርቬሽኖች የተመለከቱ ጉዳዮች ላይ አንድ የሲዳው ፈራሚ ሀገር ናሽናል ኢንዲቪጁዋል ኮምፕሌንት ቢያስገባ በነዛ ሪዘርቬሽኖች ላይ there won't be a decision and a reservation would make a case inadmissible. It's one of the grounds to make a case inadmissible. And another thing that might render a case inadmissible relates to date of ratification. So the date on which the state becomes a party to the treaty and accepts the supervisory mechanism must also be taken into account. Generally, the complaint must relate to events that occurred subsequent to the entry into force of the complaint mechanism for the respective state. As a rule, supervisory bodies do not examine complaints dating from a period prior to the entry into force of that specific treaty, in which case the complaint would be regarded in legal terms inadmissible. There are, however, exceptions. There are exceptions in this case. For instance, where the effects of the event in question have extended beyond the period covered by the complaint mechanism, and this itself would constitute a human rights violation. The supervisory body may consider the overall circumstances, but the general rule is that for violations that occur before the entry into force of the treaty or the complaint mechanism will not be entertained. In the same way, in domestic legal systems, that the criminal law will not, apply retrospectively. A treaty also will not apply retrospectively. So, if a state have not signed a treaty, then the individual complaint mechanisms will not work for a time prior to signature. So an individual could only file a complaint for a violation, for a human rights violation that happened after the signing of the treaty or after the ratification of the treaty. But as I said, only exceptionally, individuals may be allowed to file a complaint for human rights violations that occurred before the ratification of a treaty, if that violation is continuing even after the ratification of the treaty. ስለዚህ ratification is the cut line between the possibility of filing a complaint for a treaty body. So this would make a certain case inadmissible if it's for a violation prior to the ratification of a treaty. So after examination of the issues that we have been discussing, you might find out that a state allegedly responsible for a violation is not a party to any human rights treaty which protects the rights violated, and in which case it would be important to check if some other supervisory procedures could be invoked. For instance, you may think of extra conventional mechanisms, and for example, you may think of the working groups within the UN, and there are many mechanisms to present complaints and human rights violations before the international flora. So individual complaint mechanism is not the only way to avert human rights violations, and even if your case is inadmissible, you can still try again another time. Individuals can file a complaint another time. So individual complaint is not the only way to avert human rights violations, and there are many other ways. So that also needs to be taken into consideration. Okay, so another issue that makes a case inadmissible before a treaty body is pendency. So if a certain case is being seen under a regional human rights system, or if it's being entertained in another international you know, treaty body, this will render the case inadmissible because there will be a duplication of procedures. So where an alleged violation is covered by more than one human right instruments to which the responsible state is a party, it is necessary to decide which supervisory body would provide the best remedy. Because you can't file a complaint for two treaty bodies at the same time, it's important to choose which of the two will serve your interests best. Filing a complaint for two or more international treaty bodies would result in a duplication of a process, a duplication of procedure, and you can't file a complaint to one treaty body while your case is still pending in another treaty body. So in order to decide which mechanism is the best choice, several factors need to be taken into account. First, we can say the specific character of a particular procedure has to be taken into consideration. Sometimes individual complaints are possible both at the universal level and under a regional system. At the universal level, we have treaty bodies like the treaty bodies of CEDAW, the treaty body of CAT, the treaty body of ICSCR. We have various committees and treaty bodies. At the regional level also, we have various courts, regional courts. For example, we can take the African Court on Human and People's Rights. We have the European Court on Human Rights. We have also various mechanisms in the the Inter-American Convention. So you need to choose between the two. You can't file a complaint in both systems. So you can file after a decision is rendered, but you can't file a complaint simultaneously at two international bodies or at two international supervisory mechanisms of a treaty. So in such cases, making a complaint under the regional system, may sometimes be preferable because regional individual complaint procedures are decided by courts which are in a near proximity to the individual, because filing a complaint to the international flora, may not be easily accessible when compared to regional mechanisms. So it's important to look into these things when choosing to file a complaint between international and regional mechanisms of human rights protection. So we have discussed the issue of pendency, and if your case is pending before another court or another human rights treaty body, your complaint will be rendered inadmissible. And another requirement that is important and worth mentioning is the issue of standing. So you need to have a standing in order to lodge a complaint. What is standing? What is locus standi? What is locus standi? Anybody who can remind us what locus standi is? Anyone with a good memory of civil procedure law? By the way, the international system, in a way is a mirror of domestic legal systems, and it reflects most of the things in domestic legal system. So it's just that it's more broad than domestic legal system. So in order to file a complaint, you need to have a locus standing. So what is a locus standing? A locus standi? Anyone who can remind us that? You can unmute yourselves and speak. Okay, who wants to speak? It is okay, Zakia. Okay. Exactly. So, loci standi or locus standing means the right to bring an action or to be heard in a given forum. So not everyone can lodge a complaint before the human rights supervisory bodies. It's a person who have an interest and a right to bring a claim. So international human rights treaties establish who can bring a complaint, so the relevant provisions in each instrument need to be checked. In most cases, it's possible to bring a complaint if you are a victim or if you are acting on behalf of the victim. Of course, with the legal consent of the victim. The consent of the victim is important for you to act on his behalf as a lawyer or as maybe a human rights advocacy group. But then again, it's important to note that there are exceptions to this rule. First, where the direct victim is unable to act, the complaint may be filed by a person who has sufficiently close links to him or to her. So that it may be presumed that the wishes of the victim are adequately taken into account and that if he or she could have done so, the victim would have consented to be represented. ለምሳሌ በአንድ በጣም አውቶሪታሪያን በሆነ ገቨርንመንት የማይታወቅ ስውር ቦታ ዲቴን የተደረገ ሰው ቢኖርና ለዛ ሰው on his behalf after exhausting all local remedies ለዛ ሰው on his behalf ኮምፕሌንት ሎጅ ማድረግ የሚፈልግ ሰው ቢኖር እና ያ ሂውመን ራይት ቫዮሌሽን የደረሰበት ሰው ያለበት ቦታ ስለማይታወቅ የእሱን ኮንሰንት ማግኘት አዳጋች ሊሆን ይችላል። ስለዚህ በእንዲህ አይነት ኬዞች ከሂውመን ራይትስ ቪክቲሙ ጋር ክሎዝ ሊንክ ያለው ሰው ፋሚሊ ሊሆን ይችላል በአብዛኛው complaint lodge ማድረግ ይችላል ማለት ነው. So this is the first exception for the need for the consent of the victim. And second exception is where the violation has not occurred, but yet it may be considered by both imminently and sufficiently consider እንድናደርግ የሚያደርግ reason በሚኖር ጊዜ ያለ ቪክቲሙ ኮንሰንትም እንትን ማድረግ ይቻላል ማለት ነው ሎጅ ማድረግ ይቻላል complaint. So it's not sufficient and simple to challenge a law or in cases where a state policy or practice is in the abstract without demonstrating your interest or your standing or without showing how you are individually affected, you might file a complaint. So this works mostly for human rights advocacy groups. Human rights advocacy groups does not have a personal interest on the case or on the issue. So if you are an individual victim of human rights, you have a personal, interest on the case. But then again, when you are not an individual victim and you are just a human rights organization, you may not have a personal interest on the issue or you may not be able to demonstrate how you are individually affected, but yet actiono popularis በምንለው መንገድ በpublic interest ማለት ነው for the sake of public interest a human rights organization may file a complaint to the treaty bodies ማለት ነው. So these are the two exceptions to loci standi. I hope this is clear, but if you have questions, you can interrupt me at any moment and ask questions. The second exception, okay. The second exception for loci standi is that even if you don't have a personal interest on the issue, you can still file a complaint on behalf of an individual. So ሎኪ ስታንዲ ስንል personal interest ያስፈልጋል. There need to be a standing in order to bring a case ማለት ነው. Unless you have an interest in a case, unless you are individually affected by a case, you can't normally present a complaint. So the exception for human rights is even if you don't have a personal interest on a case, if you are a human rights advocate or if you work for a human rights organization, your organization can lodge a complaint on behalf of that individual whose human rights is violated. For example, let's say that you work for a human rights advocacy organization, for a women's rights advocacy organizations. So that women's rights advocacy organization can bring an individual complaint before an international body for a woman whose rights are violated. ለምሳሌ አንድ ጥሩ ኬዝ ኢትዮጵያ ውስጥ ያለ አንድ ጥሩ ኬዝ አለ። ኢውላን ባለፈው አንስቼላችኋለሁ። ኢውላ is quite famous on women's rights እና አንዲት ወይንሸት የምትባል ኢትዮጵያዊት ወጣት ልጅ ነበረች እና she was abducted በጣም ብዙ human rights violation ደረሰባት ሴት በመሆኗ። ስለዚህ ኢትዮጵያ ውስጥ ያሉ ፍርድ ቤቶች ምንም አይነት ሬሜዲ ሊሰጧት አልቻሉም ለልጅቷ። ሶ ኢውላ ሄደች እና ኢውላም ሞከረ ብዙ ነገር ግን nationally there was no remedy for the girl. So ኢውላ took the case to the African Commission, and there the case was decided. So in this case, Eula is not individually affected. It's Wainishat, it's the woman which is individually affected. But yet, Eula presented the case to an a regional human rights body on behalf of Wainishat. ስለዚህ personally affected by honim Eula, ግን as a human rights advocacy organization, it presented the case to the regional system. ስለዚህ exception ይሄ ነው. Without having an interest, you can still file a complaint ማለት ነው. የመጀመሪያው exception ደግሞ እንደተነጋገር ነው the victim himself consentun መስጠት አለበት ሌላ ሰው on behalf of him እንዲሟገትለት the victim need to give a consent. But the first exception, as we have seen, is in cases where the victim is disappeared or his whereabouts are not unknown. Someone close to the victim, even without the victim's consent, may file an application or a complaint before a treaty body. These are the two exceptions. I hope it's clear, but if there are questions, I can also answer. Anyone who have questions? Okay, please continue. Okay. Yeah. No, that's not possible. Like, if you need to wait for the decision to be rendered. So if you have presented your case to the treaty body of the ICCPR, which is the Human Rights Committee, and then you have to wait until a decision or a final opinion is rendered. And only it's after that you can present your case to another treaty body. So you can present your case to various treaty bodies, but it should be only after you have received a decision from the respective treaty bodies. So you need to wait. I mean, this is one of the feedbacks and setbacks of the international system, but yes, you need to wait until a decision is rendered, but you can, present your case to various treaty bodies, and that is possible. Yeah. Yeah, it's in a way, a mechanism to find, a remedy. Because if you can't get a remedy from one treaty organ and then you go to the other in search of a remedy, in search that your human right violation, would be averted. Yeah, but still, I think it's good for the individual, and there are not many treaty bodies which have, similar rights. For example, um, if you have been to the Human Rights Committee, the treaty body of ICCPR, you can raise a similar issue only in few of the treaties. So, you might not have, much room to, go here and there between treaty bodies. But, some of the regional mechanisms might, require that there need to be a consideration of res judicata. Some of the regional systems, such as the African regional system, requires that a certain decision to be rendered. I mean, if a certain decision is rendered by an international treaty body, then, you should wait for that decision to be enforced, and if that decision is not executed and if it's not effective, and then you might present to the African regional system, human rights bodies. But it's possible, to file your complaints across various places, but you can't just file to a treaty body without receiving a decision from the other. Like, you can't do that simultaneously, as we said, and as I know, that it's clear that there need not to be a pendency. But apart from that, the issue of res judicata is mostly present in national legal systems, and within the international legal system, the issue of res judicata is of less importance. I hope it's clear, but you can follow up with questions, Ruhama. Yes? Okay. Okay, قتل. Yeah, yeah. ውክልና ባያገኙ እንትኖቹ ኦርጋናይዜሽኖቹ ነው ፍቃድ ባያገኙ የኢንዲቪዥዋሉን ፈቃድ ባያገኙ ነው የማንም ፈቃድ አይ ሚን ሁዝ ፍቃድ ያ ያ ያ ያ Okay. Oh, yeah. Today we're talking about individual complaint mechanisms. ስለዚህ ይሄ ስለ ኢንዲቪዥዋሎች ነው ዛሬ የዲስከስ እያደረግን እያወራን ያለ ነው። እንደ ማህበረሰብ ያሉ ሂውመን ራይት የግሩፕ ሂውመን ራይት ቫዮሌሽንስ ነው እያልከኝ ያለሁ ይመስለኛል። Yeah, so Yeah, yeah. So today we're discussing the individual complaint mechanisms, and an individual within that group, may it's possible for the individual within a group to file an individual complaint. Like እንደ ግሩፕ ያለኝን መብት ኤክሰርሳይዝ ማድረግ አልቻልኩም ብሎ ኢንዲቪዥዋሊ ራይቱን መጠየቅ ይችላል። as you know, this gamut of the international human rights system is basically focused on individual rights. It's a way to protect the individual from the pressure of the government, from the human rights violations which might be perpetrated from the government ማለት ነው እና በግሩፕ ውስጥ ያለ ኢንዲቪዥዋል መጠየቅ ይችላል መብቱን ግን like group rights are not as such given much due attention when compared to individual rights. And also today the scope of our today's discussion is on individual complaint mechanisms. So racial discrimination ወይም እንደዚህ ያጋጠመው individual, yeah, it's possible. The CERD has the Convention Against Elimination of Racial Discrimination have an individual complaint mechanism, and using that, a certain individual who is racially discriminated can file a complaint. And I hope this answers your question, but if it's not clear yet again, you can ask. Yeah, so እስካሁን ምን አየን? የአድሚሳቢሊቲ ሪኳየርመንቶች መሆን ያለባቸው መጀመሪያ ያየነው ratification. The country need to ratify the specific treaty, and it must accept the competence of the supervisory body, and also there need to be a material admissibility. There need to be a violation of a right within that treaty ማለት ነው. And then again, we have said that there should be no reservations on the part of the state. If the state have made reservations, this may make a case inadmissible. Also, we have seen that the date of ratification matters, and treaties do not work retrospectively, and the alleged violation should happen after the treaty is entered into force. And then we have seen the issue of pendency, that there should not be other pending cases. The case cannot be presented simultaneously between two treaty bodies. And we have also seen the issue of locus standi. So finally, we have the last requirement to see whether a case is admissible or not, and that is the rule of exhaustion of local remedies. Local remedies need to be exhausted before a certain communication or a petition or an individual complaint is brought before a treaty body. So this is a crucial rule. It is a critical rule which governs the admissibility of complaints, and you must in general exhaust local remedies within a state where the violation occurred before bringing a claim to an international body. This usually includes pursuing your claim through the local court system. However, there are exceptions to this rule also, as there are exceptions to the locus standing rule. This rule of exhaustion of local remedies have also exceptions, and these exceptions are if local remedies are unreasonably prolonged, or if they are plainly ineffective, or if they are otherwise unavailable to you. You can present your case even if you have not exhausted local remedies, because the local remedies will stop being remedies if they are prolonged if they are unreasonably prolonged, of course, and if they are ineffective or if they are not available, it means that you have no remedy and you have already exhausted what is available for you. And if that's not working, you can present your case to an international body nonetheless. So, for example, if you are, denied legal aid, if you're not given a remedy by, the state, or if the state is intentionally denying your rights, and if it's intentionally creating, bureaucratic hurdles to violate human rights, and if the domestic legal remedies are not ineffective, as I said, if they are not available in the first place, or even if they are available and if they are unreasonably prolonged, justice delayed is justice denied, and you can present your case to the international treaty bodies even though you've not exhausted local remedies. Yeah, so also there is this issue of period of limitation, which may be raised because usually domestic legal systems have a period of limitation to present a case. Generally, for the international human rights systems, the ICCPR, for instance, does not have a time limit, so there is no period of limitation to present your case before the ICCPR treaty body, which is the Human Rights Committee. But for the Convention on on the Economic, Social, and Cultural Rights, you need to lodge your complaint within 1 year. So there is a period of limitation for economic, social, and cultural rights. But for rights within the ICCPR, there is no period of limitation. And usually for human rights, period of limitations are less likely to be used because human rights violations are of a grave nature, and they need to be litigated, or they need to be given attention, even if there is a period of limitation rule in domestic legal systems. There is no such strict rules under international human rights systems in order to uphold human rights ማለት ነው። ያ በእኛ እንትን ራሱ ማለት ነው ባይ ዘ ዌይ በእኛ ህገ መንግስት ራሱ ፔሪድ ኦፍ ሊሚቴሽን ከሌለባቸው ነገሮች አንዱ is crimes against humanity, genocide የምንላቸው they have no period of limitation ለመክሰስ ማለት ነው። ስለዚህ in the same vein we can say human rights are to be litigated despite any kind of period of limitation whatsoever. So on the substance of the complaint, the supervisory bodies, or the treaty bodies you may call them, would consider individual complaints inadmissible if you are unable to sufficiently demonstrate the facts of your complaint, and if you tend to establish a violation of rights which are not guaranteed by the specific convention. So you need to sufficiently substantiate the individual complaint. If you are filing the complaint on behalf of an individual as a lawyer, you need to sufficiently substantiate your complaint before the relevant supervisory body considers it. If it's not sufficiently developed, if the arguments are not substantiated on the violation of the treaty in question, the treaty body may reject the claim as insufficiently substantiated, or it might say that it's manifestly ill-founded. So substantiating the violation and relating it with the concerned treaty is very important. So these are some of the requirements of admissibility before international human rights treaty bodies. Maybe I can try to summarize what we have been seeing so that it will be clear for you. Before I summarize it, if you have questions, you can ask. Any questions? Anything that's not clear? Something that you've missed? Okay, please continue. Yeah, so 1 year after exhaustion of local remedies, as soon as the person knows that the local legal system does not bring a remedy, the complaint need to be filed. And for the question, why is ICSCR providing time limitation? I think it's because it deals with economic, social, and cultural rights. And economic rights, as you know, are of, immediate nature. For example, if you are evicted from your house or, from your land, or if it's a certain claim on property, anyways, it's something of economic nature, and that is not, in a way comparable to civil and political rights, which concern, the right to life, the right to be free from torture. So civil and political rights, are something, very critical. I'm not saying that socioeconomic rights are any lesser, but civil and political rights are way too much critical, because maybe an individual is filing a complaint against a capital punishment from the state. So the state may arbitrarily detain you, and then after your arbitrary detention, the state may sentence you to a capital punishment, and then you might want to file an individual complaint to the treaty body. So and then again, you might file an individual complaint on your right to property. So when you compare the two, in a way, the rights concerning life and rights concerning to be free from torture would, have more weight. And these are gross human rights violations. They are crimes against humanity. So putting a bar or a period of limitation against those rights, would have much more consequences than economic rights on property and the like. And as I said earlier, economic rights have, a certain kind of immediacy feature. So you want a restitution as much as soonly as you can, so as soon as possible. So if 1 year has already passed, maybe you may already lose your rights. So filing a complaint would be meaningless. So filing the complaint as soon as you can within a certain period of limitation would actually help protect your rights, because the sooner you file the complaint, the sooner your economic interests will be upheld. But if you file your complaint late, you might have at that point lost many things, and the remedy from the treaty body might also be ineffective. I guess this is, this might be the reason behind it. But then again, yeah, you can think of other ways why this is the case with the International Convention on Economic, Social, and Cultural Rights. Okay, please continue. Oh, no, no. The specific treaty body will see issues within that treaty. For example, the treaty body of the ICCPR will see violations under the ICCPR only, not violations on the African Human Rights Convention or the European Human Rights Convention. The CEDAW treaty body will, the CEDAW treaty body is the CEDAW committee. The committee will see only violations under the CEDAW, not the, the African Women's Human Rights Convention or instruments, or the American Women's Rights Conventions and Human Rights Treaties. So it's only the international specific treaties that each treaty body will investigate. No, there's a possibility for an individual to have a second remedy, but not not under that same treaty. So international ለምሳሌ ሲዳው ትሪቲ ቦዲ ላይ የሂውመን ራይት ቫዮሌሽን ደርሶብኛል ብላ የምታመለክት አንዲት ሴት በአፍሪካ ኮርት ኦፍ ሂውማን ኤንድ ፒፕልስ ራይት ወይም አፍሪካን ኮሚሽን ላይ ማመልከት እንትን አትልም፣ ከማመልከት አትታገድም ማለት ነው። Yeah. Any other question? And before we summarize this? Okay, ሰዓትም ሄዷል። It's 4:00 ሆኗል already. So for the next week እዚህ አልኖርም። ለnext week I'm not available ማለት ነው። ስለዚህ I want to give a movie review assignments ለሶስት ክላሶች ከዚህ በኋላ እንገናኝም, and we will arrange makeup classes የእናንተን ሰዓት በማይጎዳ መልኩ ኦልሬዲ ሰርቻለሁ። ከሪሃና ጋራ እናወራና የእናንተን ሰዓት በማይጎዳ መልኩ ሜካፕ ክላስ እናዘጋጃለን። ለቀጣይ 3 ክላሶች አንገናኝም። እስከዛ ግን ሙቪ ሪቪው አሳይመንት መስጠት ፈልጋለሁ። ወደዚህ ዲስከሽን እንመለሳለን ኔክስት ታይም ስንገናኝ። anyone who wants to take a movie review assignment ወደ 7 ሙቪዎች አሉ። ሜቢ ቻት ቦክሱ ላይ ልጽፍላችሁ እችላለሁ። አሳይመንቱን የምትወስዱት ልጆች you will review the movies and tell us how they are relevant to human rights, and ሌሎቻችሁ ደግሞ እንግዲህ የማንገናኝባቸውን ክላሶች you can enjoy your time በሙቪ ማለት ነው። ከሂውመን ራይትስ ጋር የተገናኙ ሙቪዎች ናቸው። ማን መውሰድ ይፈልጋል? ላስት ታይም ፕሬዘንት ያላደረገ so I only take students who have not presented last time. Yeah, it's out of 10. Yeah, it will comprise 10% of your grade for this course. Yeah, here you go. Jami would want to take. Who has a question? Jami Yadar. Okay, Noura, you want to take a movie review? Okay. እሺ ጊዜ ለመቆጠብ ለሪሃና ትነግሯታላችሁ የትኛውን ሙቪ እንደምትወስዱ ማለት ነው። ጊዜ እንድንቆጥብ። I think you have a class next up. Okay, I thought you have a class 10:40 ላይ ክላስ የላችሁ? Okay, it's cancelled. Oh, so yeah, we can't continue our class. The rest of them may not like you for telling me this information. Okay, who want to take the movie reviews? 3 people have taken. I have slots for 4 people. 4 more people. Yeah? You do? Okay, who are you? Let me see. Okay, Qaddus. Anyone who wants to take the assignment? Yadar, I have picked your name. Yadar, Jami, Nura. Okay, how we want to take? We. Who else want to take the movie review? Sarun. Okay, Sarun. It's one person. Okay, Hera. Okay, so which movies do you want to take? Because we have time. Blood Diamond, okay. So maybe you have seen these movies in the past, but for this assignment, you will just briefly tell us the summary of the movies, and then you will identify for us, and then you will discuss for us the relevant human rights issues within each movie. So, okay, who's that speaking? Desert Flower. It's who? It's Saro? Okay, okay, Hera. Yes. Uh, who is speaking? Is it Kia? It's Howie? It's it's Howie speaking? Okay. Okay, please, what are you saying? I mean, I can't hear you. Can you just be a bit louder? In the chat box, you can see the movie titles. Okay. So what can I do for you? So the first one is Beasts of No Nation. The second one is Blood Diamond is already taken. Desert Flower is already taken. The Boy in Stripped Pyjama is not taken. Okay, The Boy in Stripped Pyjamas. Okay, Howie. The Boy in Stripped Pyjamas is taken by Howie. The Last King of Scotland is taken by Qudus. Last King of Scotland. Okay. Who else? Howie Heran has taken Desert Flower. Jami, which of the movies do you want to take? Beast of No Nation. Beast of No Nation is taken by Jami. Who is that speaking? Desert Flower is already taken by Heran. So the other movies are also nice ones. You can take either Zero Dark 30 or The Report. Okay, Zero Dark 30 is taken by Taron and Noura. Noura, you're just left with the option of taking The Report. You have been silent. Noura, are you here? Okay, you'll take The Report. Oh, yeah, The Report. So I'll also send this list to Rihanna in case you're not able to see the list from the chat box. Yeah, so Saba wants The Report. Saba, okay. Saba has already presented a movie review last time. Please unmute yourself if you're not speaking, or I'll mute you otherwise. Oh yeah, Saba, so you have presented last time a movie review for us on Salma, on the movie Salma. So you are already evaluated on that, and so yeah, that's okay. Okay, so we can continue the class. I mean, we can wrap up today's class just in 15 minutes. Is that possible? Okay, who have a question? You may continue. Okay, Zach. Okay, Zach, continue, please. Yeah, 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 yeah. Hmm. I have not thought about that, but yes, that's possible. Maybe I'll send you assignments ለሪሃና ልክላትና yeah, that's possible. But for now, I just thought about giving the movie review assignments. There are also individual assignments such as the one last time. They will be presentations on that as well. The movie review is also a presentation, so you will tell us the summary of the movie and what human rights issues are there. You need to identify at least three till five human rights issues and present for us in just 5 till 7 minutes as last time. So yeah, individual assignment-ንም እሺ ያስብበታለሁኝ ይሳቅ. Thank you for pointing that out. አስቀድሜ መስጠት እችላለሁ ግን እስከዛ እንትን እንድትሉ ብዬ ነው። ኢንዲቪዥዋል አሳይመንት አለ አይደለ የተርም ፔፐሩ yeah, so it's just to give you time to do the term paper for the week that we're not meeting. You can focus on your term paper and the presentations እንደዚህ በሾርት እንትን ማለት ነው yeah. The deadline is on February 19. I was about to discuss that with you at the end of today's class. It's on February 19. February 19 is the day where class will end for this semester. You want an extended deadline? Yeah, we'll talk on that, but the class will end on February 19 for this semester, so that will be the deadline for the assignment. That's the, the maximum, where we can go. Okay, any other question on the things we have been discussing today? Today we are seeing individual complaint mechanisms before treaty bodies, and we have seen that there is the admissibility stage and the merit stage. We have... Who is unmuting? Who is unmuting? Saron, can you mute your mic for us? Please mute yourself. Okay, I've muted Saron. I hope the meeting is now clear. Okay, so we have seen the admissibility requirements that are needed before treaty bodies. I hope they are clear, but if there are questions, I can also entertain those. Okay, Ruhama, please go on. Ruhama, your voice is not clear. You said movie reviews, and you want to know whether they are what? Yeah, yeah. Uh, so the plan was not to give double assignments to students. So those of you who have presented both the Selma movie review and the individual presentation we had last time, I will take the best grade from the two. So if you have scored best in the individual assignment you presented last time, I'll take that. Or if you have done best on the Selma movie review, I'll take that. It's just almost five students who have presented on the Selma movie review. So it's just about the five of you, and I'll take the best for you. But for all other students, I'll take either the individual presentation or the movie review, whichever they choose to present. So ከኮቪድ በፊት ስለነበረ ነው የሰልማ ሙቪ ሪቪው እና ሰልማ ሙቪ ሪቪው ያደረጋችሁ ልጆች ባለፈውም ድጋሚ ኢንዲቪዥዋል ፕሬዘንቴሽን ወስዳችሁ ነበረ። ስለዚህ ለእናንተ ከሁለቱ የተሻለውን ወስድላችኋለሁ። ግን ለሌሎች ተማሪዎች ግን ሁለት ነገር በአንዴ ፕሬዘንት ስለማያደርጉ አንድ ነገር ብቻ ስለሆነ ፕሬዘንት የሚያደርጉት ችግር አይፈጠርም። ሶ ፕሬዘንት ባደረጉት በዛ እንትን እላለሁ ማለት ነው። I hope this is clear. Was this your question though? Like I did not hear you clearly and I was just guessing the question. Okay, okay. In the chat box, okay. I'm sorry, I've not seen them. Okay, the first requirement. So the questions seem to be written in the middle of the lecture. So, you know, I would prefer if the people who have written the questions to just clarify it a little bit because it needs context. Yeah, so Rihanna, what was your question? Yes? The question you write on the chat box. I think in the interest of time, because we don't have much time, it's good just to consult the teaching material and see the human rights instruments, which I have sent you. It's a compilation of all the human rights instruments, both international and regional. So seeing those two, I think, would be enough because only we have few days remaining. We don't have the luxury to go through different materials. So I think that would be enough. Even for the exit exam you're having next year, I guess it's next year in Ethiopian calendar. So even for that, it's the teaching material. So with all its defects, in interest of time, we need to focus on that. And the human rights instruments compilation as well. I'll send you other materials if I find them relevant. and for the Ethiopian human rights system, most of you are doing assignments on the Ethiopian human rights system, so you can also consult various materials on Ethiopian human rights system while doing your assignments. And you also have another question, Rihanna, which is written in the chat box. I'm not sure if I have answered it for you in due course, but if it's not yet answered, you may kind of clarify it. It's on disappearance, I guess. Yeah, on disappearance. But it seems that you have raised that question in a certain context, and maybe if you can explain that context, if it's not yet answered, I can answer. Okay. Kia, which of the questions are you referring? Jonas, okay, Jonas have a question also. Okay, it's not a question, it's an explanation, I guess. Okay. Okay. Okay, Noura. Noura, your movie review will be on. Noura's. You will be doing a movie review on the report, Noura. On the report. Okay. So if there are no more questions, let me summarize this class. Yeah, so the admissibility requirements are clear, አይደለ? እባካችሁ ያልገባችሁ ነገር ካለ ጠይቁ. Please ask questions if something is not clear. So if there are no questions, I can proceed to summarizing the admissibility requirements for you so that it would be more clear. The first admissibility requirement, you may take notes, and I can speak slowly so that you can take notes. The first admissibility requirement to present an individual complaint before a treaty body is ratification of the respective international legal instrument and the acceptance of the competence of the treaty body. So ratification of the international legal instrument and acceptance of the competence of the treaty body is the first requirement to admissibility. The second requirement is material admissibility. There needs to be a material violation of human rights for the case to be admissible before the treaty body. ስለዚህ ቫዮሌት የተደረገ መብት ላይ ነው ኢንዲቪዥዋል ኮምፕሌንት ማቅረብ የሚቻለው ማለት ነው። እና ደግሞ ያ መብት በዛ ትሪቲ ከቨርድ የሆነ መብት መሆን አለበት። ስለዚህ በሴዳው ኢንዲቪዥዋል ኮምፕሌንት እያቀረብን ነገር ግን ሶሾ ኢኮኖሚክ ራይት ክሌም ማድረግ አንችልም ማለት ነው። ለሴዳው ትሪቲ ቦዲ የሶሾ ኢኮኖሚክ ራይት ቫዮሌሽን ማቅረብ አንችልም unless that socio-economic right is in ሴዳው ማለት ነው። usually women's right ላይ ነው ለሴዳው treaty body individual complaint ማቅረብ የምንችለው. And the third requirement for admissibility is the one that relates with reservations. So the state should not have entered into reservations on that specific right on which the individual is filing a complaint. So there should be no reservations, or the reservation should not be a one relating to the violated right. And the fourth requirement of admissibility relates to the date of ratification. The violation should occur subsequent to the entry into force of the specific treaty. So international treaties don't work retrospectively. And the fifth requirement of admissibility is on pendency. There should not be a duplication of procedures, and the case should not be pending in other international human rights bodies or other treaty bodies. And then the seventh requirement of admissibility concerns with locus standi. There need to be a standing for you to lodge a complaint, an individual complaint. You need to have a personal interest, a vested interest on the case. There are exceptions to this, as we have discussed. The first exception is that if the person could not give his consent, people who are close to the victim may file a complaint even without his consent, because we presume that he may have given his consent to them. As we have discussed, if the government have, made someone to disappear, or if the person is arbitrarily detained and his whereabouts are not known, a close family member or someone with close links to him may file a complaint without his consent, assuming that he would not deny a consent. And second, exception to locus standi of personal interest is the issue of human rights advocacy organizations. We have raised the example of EULA, and also other human rights advocacy organizations can bring a complaint, and this is the second exception. And the eighth admissibility requirement is the rule of exhaustion of local remedies. So all domestic legal remedies should be exhausted before a case is brought to an international flora, an international treaty body. እዚህ ጋር ባይ ዘ ዌይ ማለት ነው ሌጋል ሬሜዲዎች ብቻ ነው ኤግዞስት መደረግ ያለባቸው። so it does not include administrative remedies. So here we are talking just about legal remedies. So if a person have exhausted all legal remedies, there is no need to go to administrative remedies such as the office of ombudsman. ለምሳሌ እንባ ጠባቂ ተቋም መሄድ የለበትም አንድ ሰው የኢትዮጵያን ዶሜስቲክ ሌጋል ሬሜዲ ኤግዞስት አድርጓል ለማለት። ስለዚህ ሌጋል ስንል we are just talking about judicial bodies, we are not talking about quasi judicial bodies or administrative bodies. You need to note this. So exhaustion of local remedies is the eighth requirement for admissibility before an international treaty bodies. There are exceptions to exhaustion of local remedies. The first exception is that if local remedies are unreasonably prolonged, the case may be filed to an international treaty body, even if local remedies are not exhausted. This is the first exception. And the second exception is if local remedies are ineffective or unavailable, the person might file an individual complaint within the international supervisory mechanisms. So these are the two exceptions. If it's unreasonably prolonged and if the domestic legal remedy is ineffective or otherwise unavailable. So these are the two exceptions. And we have also raised the issue of period of limitation and the issue of the substance of the complaint. With regard to period of limitation, for the ICCPR there is no period of limitation, but for the International Convention on Economic, Social and Cultural Rights there is a 1-year period of limitation. So generally we have seen that human rights treaties do not have period of limitations. And we have said that the substance of the case need to be well founded, and it need to be substantiated. The arguments regarding the violation of the treaty need to be put forth very well, otherwise the treaty body may regard the case inadmissible or insufficiently substantiated or manifestly ill-founded. So these are some of the things that we have discussed today. I hope it's very clear now. If you have questions, however, I can answer. And one thing I did not mention is that there are also interim measures that treaty bodies usually take. These interim measures may be somehow similar to domestic legal systems. For example, if the violation that you are facing is of extreme gravity and urgency, and an immediate action is required in order to avoid an irreparable damage to you, then the treaty body may provide for interim measures so that, you know, further violation of rights is not perpetrated and you don't incur an irreparable damage. So you can request, the individual can request the supervisory body to adopt interim or provisional measures. That is to take, you know, an urgent action to avoid damage to the individual, and under certain circumstances the supervisory bodies may adopt such measures on their own initiative or at the request of the individual. When the individual requests interim measures to be adopted, it's advisable that the urgency of the situation and the measures to be taken to avoid the damage are clearly described. The individual should ask the committee or the treaty body in the clearest possible sense. And in addition, you can also, as an individual, approach the relevant, you know, NGOs for help when asking such interim measures. So finally, after looking into the matter, as I said, the treaty body will issue a decision and a finding, and it may give a compensation to the individual, or it may ask the relevant state to change its legislation which is violating the rights of the individual, or it may ask the state to stop, to succeed all violations it is perpetrating against the individual. So these are the possible remedies that an individual could get from a treaty body: compensation or a request for a change of legislation that violated the right of the individual, or remedies that would request the violating state to immediately cede all actions that violate the rights of the individual. So these are the possible remedies. I hope it's clear. If you have questions, you're very, very welcome to ask, and I can clarify on those. Anyone with a question? Okay, so if there are no questions, we will see the final mechanism to protect rights within the treaty-based mechanism, which is the country visits and inquiries in our next session, in our next class, and then we will finish the treaty-based mechanism, and then we will go on to the charter-based mechanism to protect and enforce human rights. Yeah, so have a good time. Even though you're not assigned to a movie review, you might see the movies and enjoy your time. I guess this is a very busy semester for you, so it's very important to take breaks in the middle, and I think the movie review is a good educational break. So yeah, until next time, goodbye.